So here are some key definitions. First of all, under the CCPA, a consumer is defined as a natural person who is a Californian resident. So if you are a for-profit business that sells to other businesses, so you're not selling to consumers, you're not selling to persons, it's just B2B, selling directly to businesses, then the CCPA does not apply to your case because your customer does not meet the definition of a consumer. Now, also under the CCPA, we need to understand what a business is. So as I hinted at before, a business under the CCPA is defined as a for-profit organization that interacts with the personal information of consumers. Now, we can actually just stop at a for-profit organization because most businesses do interact with data that's considered personal information. This can include anything from first name to IP address. Actually, the definition is anything that could possibly identify a person, that could lead to the identification of a person, is considered personal information. Now, so to carry on, the business also determines the purposes and the method of the processing, which if we want to compare it to the GDPR, this is sort of what a data controller does. So if the processing is for your own purposes, therefore you are determining the reasons and the ways that you are processing information. Now, this business must also target Californian residents, whether or not the business is actually based in California. So even if you're based in Europe and you are targeting, or you could possibly have Californian residents in your user base, and you meet one of the following requirements that are coming up, then it possibly applies to you. So there is a lot of qualifying details here, and it's easy to get lost. The long and short of it is, if you're a for-profit business not doing B2B, and you could possibly have Californian residents as a part of your customer base, then it's likely that the CCPA applies to you. And to just sort of finalize that last step to see if it applies to you or not, we're going to look at what the following requirements are. So the first one is if your business derives at least half or more of its annual revenues from selling the personal information of consumers. Now, selling under the CCPA does not necessarily mean the traditional idea of selling. It can simply mean sharing or making available. So for example, in a way that you profit off of in any way, whether directly or indirectly. So something like, and I might go into this a little bit deeper on the next slide, but something like even using Google Analytics can technically be considered selling behavior under the CCPA, because you're sharing IP address information for retargeting or just for your own ads or whatever, and therefore it is considered selling. So if at least 50% of your annual revenues come from this, then automatically the CCPA does apply to you. The second option, and just to reiterate, if any one of these three applies to your for-profit business, which targets Californian residents, then the CCPA does in fact apply to you. So the second one here is if you buy, receive, sell, or share the personal information of at least 50,000 consumers annually. So another way to interpret this point would be if you have a website that possibly has at least 50K unique visits from consumers that could be from California annually. And for most medium to large size businesses or enterprise businesses, this is a definite. So this is just 50K for the entire year. And if they could possibly be from California, then this again likely applies to you. The last one is one that's a little bit harder to meet. It's if you have annual gross revenues exceeding $25 million, then automatically, again, the CCPA applies to your business. And of course, because this is all a little bit confusing, they're still sort of working out the law here. If you have any questions about this at all, please feel free to add it to the questions tab. Now, we're still doing a lot of defining, because under the CCPA, a lot of things are not exactly what you might take the word to mean in plain English. So, as I hinted at before, personal information can include things like IP address. So, under the CCPA, personal information is defined as information that identifies, relates to, describes, is capable of being associated with, or could reasonably be linked directly or indirectly with a particular consumer or household. So this is the actual word for word definition in the official documents. As you can see, it's quite, legal. As they try to cover every single possible point, but the long and short of it is any information that could possibly lead to the identification or be linked directly or indirectly with a consumer or a particular household is considered personal information. And as I also touched on before, so we're just going to look at the actual legal text here. A sale within the context of the CCPA is defined as either selling, renting, releasing, disclosing, disseminating, simply making available, transferring, or otherwise communicating orally, in writing, or by electronic or other means a consumer's personal information to a third party for any benefit, monetary or not, that you would not otherwise be legally entitled to. Therefore, something as simple as having analytics, having Google Ads running on your site would fall under the sale definition of personal information.